Hello, beautiful people. Welcome back to our channel. Some hours ago, yesterday actually, Aloy Ejimakor, one of the legal team of Nnamdi Kanu, handling the international arm rightly under Bruce Fein, has actually written to the court in Abia State, made a lot of demands, demanded about 5 billion naira on health issues and many others, listed about 8 or 10 infringement on Nnamdi Kanu. And right now the court has replied, and this seemed to be the super excitement in the air. Lots of social media reactions over the reply of the court. In the moment, going to give you the breakdown and the lowdown of what the court has to say. But before we do so, like you, subscribe to our channel if you have not done so already by clicking on the red subscribe button beside it. You see a bell notification icon. Please, by all means, go ahead, click on it to get notified as soon as you update our channel on YouTube. An Abia High Court sitting in Umuahia and presided by Justice KCJ Okereke yesterday granted the leader of the indigenous people of Biafra, Nnamdi Kanu, leave to serve in a court process to the respondent in the suit he instituted for the enforcement of his fundamental human rights. The respondent in the suit filed by Nnamdi Kanu's counsel, Aloy Ejimakor, include the Federal Republic of Nigeria Attorney General of the Federation, Federal Chief of Army Staff, and Brigade Commander 14th Brigade of the Nigerian Army on Hafia, Abia State. Others are Inspector General of Police, Commissioner of Police, Abia State Director General, Department of State Services DSS, and Abia State Director of DSS. The order was sequel to a motion expert brought by counsel to the IPOB leader in pursuant to Order 3, 4, and 5, Rules of Fundamental Rights Enforcement Procedure, Rules 2009. After going through the affidavit in support of the motion paper as well as written address of counsel, and after hearing Aloy Ejimakor, counsel to the applicant, the judge granted leave to the applicant to serve all the court process in the suit through substituted means upon the respondent. The judge also ordered that the applicant put all the respondents on notice of the application and fixed September 21st, September 21 for the return date for the motion on notice. In a release after the court sitting, Kanu's counsel Ejimakor said the material issue in the suit was the unbroken chain of infringement which he stated began with the 2017 extrajudicial attempt on Kanu's life in Abia State, his involuntary flight to safety or exile, his abduction in Kenya, and his extraordinary rendition to Nigeria. We believe that these supervening issues have complicated Kanu's prosecution and thus must be judicially dispensed with before any further prosecutionary action can proceed. In light of the above, therefore, Ejimakor said he has placed before the court the following reliefs. A. 1. A declaration that the military invasion of the applicant's building and premises at Isiama Afaruku Ibeku, Abia State on September 10, 2017 by the respondent or their agent is illegal, unlawful, unconstitutional, and amounts to infringement of the applicant's fundamental right to life, dignity of his person, his personal liberty, and fair hearing as guaranteed under the pertinent provisions of Chapter 4 of the Constitution of Federal Republic of Nigeria 1999, hereafter called CFRN, and the African Charter on Human and People's Rights Ratification and Enforcement Act, hereafter the Charter. A declaration 2. A declaration that the expulsion of the applicant from Kenya to Nigeria by the respondent or their agent and their consequent detention and planned prosecution of the applicant in charge number FHC/ABJ/CR/383/2015 Federal Republic of Nigeria versus Nnamdi Kanu is illegal, unlawful, unconstitutional, and amounts to infringement of the applicant's fundamental right against unlawful expulsion and detention and to fair hearing as enshrined and guaranteed under the pertinent provision of CFRN and the Charter. 3. An order of injunction restraining respondent or their agent from taking any further step in the prosecution of applicants in charge number FHC/ABJ/CR/383/2015 Federal Republic of Nigeria versus Nnamdi Kanu, pursuant to say unlawful expulsion of applicants from Kenya to Nigeria. 4. A order mandating and compelling the respondent and their agent to forthwith release the applicant from detention and restitute or otherwise restore applicant to his liberty, same being his state of being as at of 19th June 2021, and to thereupon repatriate the applicant to his country of domicile, which is Britain, to await the outcome of any formal request the respondent may file before the competent authorities in Britain for the lawful extradition of the applicant to Nigeria to continue his prosecution in charge number FHC/ABJ/CR/383/2015 Federal Republic of Nigeria versus Nnamdi Kanu. An order mandating and compelling the respondent to issue an official letter of an apology to the applicant for the infringement of his fundamental rights and publication of said letter of apology in 3 national dailies. An order mandating and compelling the respondent to pay the sum of 5 billion naira to applicants being monetary damages claimed by the applicant against the respondent jointly and severally for the physical, mental, emotional, psychological, and other damages suffered by the applicant as a result of the infringement of the applicant's fundamental right. A lot of jubilation is going on in Nigeria. We're going to take 1 or 2 comments just quickly, but we'll look at this in summary. Why the jubilation, and what I guess they really do not understand much what this means. This one here is saying that is only okay. This one here says that's only if the country will understand what court order says. This one here is saying nice move, congratulations to Ejimakor's team and a big win for MNK. Let's be watching. This one says okay, well, let's keep watching. That serves the federal government well. The damage is even worth more than that, but let the government respond to this ones first. This one says powerful. This one here is saying all the human rights violations carried out by this government will not go without consequences. Every citizen of this soil must also file a suit against this government for gross human rights violations of the Igbos. Extrajudicial killings is the order. Now they will be treated in a language they can understand. Once all the money they have been both stolen and borrowed has been used to pay back to the public they stole from, we shall see. All right, but let's quickly look at this. I do not know why they are overexcited. There's overexcitement, but the truth is from what I gathered, is a go ahead. So it's like a go ahead and serve them notice, okay? And the date has been slated 21st of September. Whatever alternative means you need to get them notified. All the respondents, the federal government, the AGF, the DSS, all those people he mentioned as the respondent, that they are on notice that they should the case has been adjourned to the first hearing will be on the 1st of September, so that they can now move forward. And judging by what I've heard, they are trying to make sure that first Nnamdi Kanu's right is firstly restored before they will now think of that federal government of Nigeria versus Nnamdi Kanu's case, which is what is pending. But they're instituting a case before the case. Don't forget that the Bruce Fein has gone to the United States, and in a very long while, all of a sudden, if you permit me to use the word all of a sudden, even CNN is now carrying Biafra news very seriously. So I think already the stories, the drama is beginning to unfold. Stories are twisting, changes of narratives are coming up. So technically speaking, we could say it's a win-win for them. Let's meet in that comment section, please. What's your take on it?